everyone, and thank you for making it, especially after the lunch. I hope you've been enjoying the sessions today. It's a big summit, and I'm personally quite glad to be here. It's very exciting to see many of you. So the session that we have right now for you is a discussion on the implications of the new data protection law on startups. And while none of the people who are sitting here are from startup industry, I think they were startups once upon a time. So I think they are in good position to tell you what they think about the implications of the law on startups. We also do know that the DPDP Act, as it's called, very, I would say, endearingly, has had a bumpy ride, but finally we got presidential assent in August of 2023. What we have now are the rules, draft rules that the government has come out with. So I was really hoping that we kick off this session with what the rules look like. So Sriram and Shivli, do you want to give us some very, very quick thoughts on what you think about the rules? Is it still work in progress? Do they give some clarity? Are they holding some promise, or there are still a lot of gaps and voids in there? Some initial thoughts before we jump into the juicy bits of this session.
Thanks, Anisha. Everyone was hit with the combination of relief and anxiety when the rules came out on the 3rd. Relief, of course, because we've been sitting in a little bit of uncertainty about what the rules will ultimately look like. And it helps that the rules complement the Act in the current version that they are. So we now finally have an understanding of what the full legislation looks like. But when it comes down to the nuts and bolts of actual compliance, and I have to prepare a roadmap for how both as industry participants and individuals will have to comply with this law. Of course, there are certain questions in the legislation itself that are still, I would say, a little bit lacking. It's overall a good thing that the law continues to not be very prescriptive. The Act wasn't, and the rules are also not something that would just lay down everything. It's more concept-based, and it's taken a slight departure from the GDPR in that aspect, I would say. But at the same time, there is some ambiguity in the law as well. It's a positive aspect that the ministry and the officials are doing consultative sessions on it so that we can give our inputs. I think an example would be Rule 6, for example, which lays on security standards, which was new. We haven't seen it in a previous version, even the leaked version of the rules that was going around. So we know that there are certain expectations of how a company needs to secure its data, but at the same time, we don't know if the standards we put into place will be considered adequate maybe 5 or 10 years down the line when, let's say, a litigation happens. And if, God forbid, there's a data breach, were our security standards adequate? Because the law today has ISO 27001 as a required mandatory minimum, whereas the Rule 6, which is now in the new rules, doesn't. So from that perspective, there are various aspects in the rules which we can, of course, go back and forth on and hope that there is a little bit more clarity. But otherwise, I think the overall takeaway is that it's a positive development. And I would leave it at that. And maybe Shivli will have something more to say about it.
It was indeed a Happy New Year gift, right? 3rd Jan, we are all kind of getting out of our New Year celebrations, and here we go. I echo Sriram's thoughts on Rule 6 as an example in terms of perhaps where something more definitive would have been helpful. And I also would like to add that the fact that there is a mental model of leeway for making changes and somewhere there is an ethos of encouraging innovation is very apparent. And both the Act, that was the flavor, and the rules kind of reiterate that. So that is the takeaway. And last but not the least, the fact that there is open conversation and it's a two-way street and not just something which is being sent to say that, hey, this is what you need to do, that is extremely encouraging. Whether you're a startup, whether you're, a big company, whether you're going to go public, whatever be the case, all of this kind of is really encouraging.
Thank you so much for that perspective. I think we've started on a good wicket, that way I would say. And I think the duty, like she said, rests two ways. So it's important that whichever organization you belong to, big, small, medium-sized, please participate in this discussion because ultimately the law will have implications on your business. So now that the forum is open, please engage, have rigorous, meaningful comments to give, and that's how we can shape something together which is better for all of us. But now turning on to the main agenda, which is startups and privacy implication. Ravi, I'm going to bring you in here. There's a common misconception that, there is an exemption for startups under the DPDP Act. And that means that if DPIIT recognizes you as a startup, then you don't have to comply with any obligations. But there are nuances to it, and we want to understand what those nuances are. Is this a blanket exemption that's applicable to all startups? Is there any criteria which the law prescribes? The rules obviously are silent on this, but just want to understand what the law says so that it's sort of clear as to what the exemption is.
Thank you very much for that question. As much as we wish that was a blanket exemption for all the startups, my reading of the law doesn't suggest so. I think a lot of that perception is coming out from the fact that the provision uses the word such classes of data fiduciaries, including startups. So that language itself is like it's inclusive. However, if we plot it on a horizontal classification and a vertical classification, the top classification is actually having regard to the nature and volume of data which is processed. So I think that exemption will depend on the kind of data that you're processing and the amount of data that you're processing. And having regard to that, if you're a startup, there could be certain, maybe a little more relaxed for startups, but there is no specific exemption, completely blanket exemption for startups. And in fact, so much so that probably, and Sumeet can chime in on this, I also have this feeling that if you look at the explanation of the word startup in the provision, it quite curiously doesn't refer to DPIIT explicitly when it had every reason to. It just says such ministry which is allocated the power to determine. And I think that is something which is going to have some implication, and we might see some new definition of startups emerge as well. If not in a generic way, then at least for the purposes of DPDP is what my sense is, but that's just my personal opinion. So yes, coming back to the question, I don't think there is any generic blanket exemption for startups. And I personally feel that's actually the correct approach. There could be startups which could be dealing in very, very sensitive data. So it makes no sense to have a complete blanket exemption for startups. However, you should have enough room to ensure that those which are not really dealing with sensitive data should not be burdened with unnecessary additional compliances. And I think government have decided to keep that room open. So yeah, to answer your question, there isn't any blanket exemption.
Sumit, would you like to add your two bits here?
So obviously, the Act actually prescribes the definition of startup, which is right now, they've just kind of left it open-ended. But if we actually read that carefully, obviously without calling DPIIT, at least my sense there is that, and I was at the same venue yesterday at Bharat Mandapan where the G20 summit took place, right? And DPIIT was actually celebrating the National Startup Day because there's been 9 years of since the launch, right? So obviously I was there for some other discussion, and interestingly, there was some discussion on the DPDP also with a very senior government official, and we'll talk about it in the course of this panel. But coming back to the startup construct, I think this definition of, because look, the eligible startup, if you look at Companies Act, if you look at Income Tax Act, there are a lot of exemptions which are anyway otherwise available under different statute. So I at least don't think that MeitY or Ministry is going to reinvent the wheel trying to come out with a different definition only to the extent of DPDP, because the same startup is getting exemptions in other statute also. So why only for DPDP they are going to come out with their own definition, right, which will only limit to DPDP, because then you have kind of why this definition will not apply other places, right? If this is good for DPDP, then why is it not good for income tax exemption or for Companies Act also? All we know, like Companies Act also refers back to it and their exemptions. For example, if you're an eligible startup, your promoters can get ESOP, right, which is otherwise not possible. So I think from a DPDP point of view, and point taken, that it should be probably in other, and we were discussing it in the rules, obviously they have called out in other definitions, kind of married it with the other statute. Here they have left it a little open-ended, but I still think because they said the relevant department which is otherwise responsible for allocating the so until now DPIT has been responsible because they prescribed 100 crore over 10 year, the different thing, and then you become ineligible, you get a certificate from DPIT, and then your lot of benefits are otherwise available for you because you are eligible startup. So obviously the large startups or unicorns may not be able to definitely get categorized under startup because the idea is also not for them because they end up processing millions of data. Yeah. So the exemption by principle should not extend to them.
Sure. No, fair point. But Ravi, I believe you also have some thoughts about this.
Just a small, one reason why I would like to believe what I was saying was probably I want some exemption for my startup. but coming back to the point, I think we have had many instances where are different. So one of in my law school experience and post that, if there is one law that I dread engaging with is labor law. And you will have 10 different definition of workers under each of those legislation. So we have had such precedents, and there are many other such examples there could potentially be. But I can see the point that you're trying to make. There is no specific obvious reason at this point in time to have a separate definition. What I feel that the pace at which this law is evolving across the globe, there could be very, very obvious reasons 2 years down the line, right? Where you may need a separate definition for startup, and I think purposely government has retained that discretion.
Yeah, no, I think all valid points, and this is, I think, just apart from you all, I do know that the House is divided on this issue. There is one school of thought which believes that within the larger umbrella of startups, if there are startups which are dealing in, like Ravi said, very sensitive data, your healthcare data, your financial data, then it is possible that even though you are a startup, because you're dealing with sensitive data, there will be rigors of the law that will be applicable to you. And the exempt will be, probably people who are just collecting your basic details like name, number, address, which is not that sensitive in the larger scheme of things. Because, if you have, and we were just discussing this, if you're dealing with, let's say, biometric analysis of data, that's super sensitive data that affects the rights of principals. So do you give them completely a get out of jail free card and tell them that, you're fine, do whatever you want, right? Send it to China, worst case scenario. But I think the point that Sumeet has also made, that you can't have two conflicting definitions, one for each law. I think that's the worst case scenario. But yeah, so the reading of the law has given two different sorts of opinions, and I think we'll need to wait for clarity on that aspect. But again, staying on, or rather, we have two experts from the fintech sector here, Sumeet and Shivli. So I want to know, and again, this has been a bone of contention amongst a lot of regulated entities. When there is, now we have an umbrella legislation in the form of a DPDP Act, and before this also, there have been certain sector regulations, particularly in the financial space, which have certain strict privacy requirements. There are consent notice requirements across the board, audit reporting, grievance redressal. So RBI, for instance, has been very, very active coming up with these sort of prescriptions for regulated entities. So what do you think? And now that it has been some time since at least the law was law got presidential assent, what have you seen as your main challenges? First, I think I just need your views on how you have reconciled the sectoral regulations with the DPDP Act. What are the challenges that you've faced? And is there any clarity that the law provides on any aspects as to which law will prevail? Because one is a specialized sectoral law and the other is a generic law. So Shivli, I'm going to start with you. And then Sumit, I would like you to weigh in, please.
Sure. I think the thumb rule, especially when it comes to specific law over general law, and of course, there is this thought that since it's data, it's the DPDP that should apply. But when you look at it pragmatically, it's the intersection of both which need to be complied with, right? More importantly, let's take the example of any financial entity which holds a license. Their priority will be to make sure that they are compliant with the rules that are applicable to them. They need to fulfill that. There are audit reports that are submitted. There are audits that are carried out by the regulator. Not to say that the regulator does not check on whether the general law that applies to you is being followed or not, right? So it's actually both that need to be done. Fortunately, in a lot of places, it's the same thing, in the sense that I would say the specificity comes from the sector that you are in. For example, if you are being governed by RBI, there is data localization requirements that are there. If it is IRDA, they are talking about localization, or they are deferring to RBI if it is payments related to insurance transactions. So you need to get into the trenches, get your hand dirty, and make sure that you understand what all would be applicable. But I would look at it in terms of an overarching framework by the DPDP, which must be complied with, and then comes your sectoral regulator, from where there cannot be derogation. So that's my line of thought. Sumeet, over to you.
So there's section 16.2, right, which is pretty interesting. And I was, when I started, I mentioned about this visit, and my some of my thoughts are still colored by a remark made by probably one of a very senior person who's involved in this process. And he said that, look, we'll sensitize all the regulators. We are the one who are going to drive DPDP, right? So probably coming from the horse's mouth, the interaction which was happening. And the said gentleman pointed out to section 16.2. He said that, look, Act is very clear when we look at it, and it's a non-obstant, that only with where any other law prescribes a higher degree with respect to transfer of data outside India is where that can apply. Otherwise, DPDP will prevail, and will sensitize all the regulators. We know IRDA, SEBI, and RBI, the three conversations are on, and we will prevail, right? So, but I think that's easier said than done. I'll tell you why. Because you have a PMLA, something like PMLA, right? KY, which prescribes that some of the data the banks and the financial institutions, NBFCs, have to keep it for at least 5 years and a maximum of 10 years. We're talking about something PMLA, which has a much larger impact, global international impact also. And look at what DPDP says, that there is a 3-year tail from the time data principle has kind of either the last service or transaction has happened, or 3 years, otherwise you have to automatically delete it. Now, play that in the case of a lending journey or a SEBI data transaction which is happening, a stock, or any lending, I think, for example, right, where PMLA becomes a very important part, or a payment aggregation business where PMLA becomes a very important part, any cross-border transaction where PMLA becomes a very important part. So I think that it still needs to be, right, because there are a lot of inconsistency, right? DPDP doesn't prohibit specifically from data to be shared outside India. Obviously, there are guardrails which have been prescribed, but when we look at digital lending guideline, which for a lot of fintechs is a very important regulation, it mandates that all the data have to be stored locally. So there are different areas, data retention, as I said, the data location norms, where still there seems to be some conflict. And that will form part of, I think, a lot of fintechs and a lot of associations already working on these representations to seek clarity on what will happen. The fact that there are arguments on both the side that a digital lending app or a LSP, whether it is really a data fiduciary or a data processor, everybody wants to be a data processor. But if you look at the role which these DLAs or LSPs play during the journey, right from the time you download, is significant. But unlike GDPR Article 26, which really delves into joint controllership, yes, DPDP contemplates a scenario where you can have more than one data fiduciary, but it doesn't. There is no really specific provision which kind of says that what happens when you have two on both sides of the aisle. You have two regulated entities, or even not regulated. A fintech, not all fintechs are regulated, right? If you're regulated, then the assumption would be you'll end up being a data fiduciary. If you have any license from any regulator, it's safe to say that you are going to be a data fiduciary. But a digital lending app or a LSP, what we call, right, under lending guideline, is not really regulated. So obviously, from if I'm wearing, and we are a payment aggregator, we have a whole bunch of, we are NBFC, there we know we will end up being a data fiduciary, but everybody, a DLA or LSP will love to be categorized as a data processor. But I think there's still some clarity which is required. And I think that especially with respect to RBI and SEBI, where there are larger considerations in play with respect to some of these data and sensitivity around it, that conversation at MeitY level and regulators still has to happen, and industry is already working towards making those representations and flagging those concerns. So we'll have to see how this plays out.
Yeah, I absolutely agree to what Sumit is saying, especially the example that he quoted is, frankly speaking, very unique, because while one would want to be a data processor, if you are an LSP, the function that you play in terms of, and the function that you play in terms of the guidelines as what has been permitted as what you can do, puts you in that area which is basically straddling both spheres. So where do you fall? Do you err on the side of caution, or you say, no, I will look at it in more holistically and at a higher level, and it's not my problem, I'm not an NBFC, and I'm a quasi or a semi-regulated entity, and that's what I'll do. But I also think that we are a work in progress when it comes to data legislation and how we implement it, and there will be a lot of change. This is just the beginning, and I don't want to sound pedantic about it, but we will see a whole lot, just like what Ravi mentioned, that there might be sectoral specific guidelines and requirements that do come in. So yeah, I'll leave it at that, and we'll all have to wait and watch.
Yeah, actually, even I had a few thoughts on this. So, and maybe my opinion is also a little colored, as is Sumit's, because what we have heard in the corridors of power, as it were, is that the government is going to, speak with the regulators, and it'll be the DPDP that will govern everything. And the only exception to that rule is with respect to localization of data. And whichever law prescribes a higher standard of protection with respect to cross-border transfer, that is what is going to apply. But of course, we haven't seen that yet, but this seems to be what is doing the rounds.
And one example just to take on is the recent amendment which happened in master directions on debit and credit card thing, right? Where if you look at the earlier, now they've actually married the provision with respect to express consent and how the consent has to be taken while you're onboarding customers for this. So, and the rationale there was obviously because it came after the DPDP came in, was to essentially align it with the requirement of the DPDP. So perhaps because, but again, I think other than data localization, PMLA is also very important.
Very, very important
aspect other than data localization, where probably RBI will definitely have a viewpoint.
Yeah, absolutely. And again, just to complete the story and tie the loose ends, even if you look at the rules, especially for governing the draft rules, I have to say, the significant data fiduciaries, what it says is that, there could be some additional classes and categories of data that may have some transfer restrictions. Right, and that what those restrictions are going to be something that a committee that is set up by the central government is going to prescribe. And that is, and again, combining this with what the minister said recently in an interview, is to say that this committee will probably consult with all the sectoral regulators equally to make sure what are these categories of data that need to be identified, and what kind of restrictions should be applied. Do we put hard localization, or do we say transfer, keep a mirror copy here, etc., etc. So all of these things will take, as Shivli was saying, it's work in progress. We are also testing various things out, but staying with the theme of fintech. And I know, Sumeet, you've already touched upon a few things specific to digital lending prescriptions, and the debate on whether LSP, which is a lending service provider, and just for context, I don't know if everybody has the knowledge of fintech here, but an LSP is somebody who's a service provider to a regulated entity. So if you're a bank or an NBFC, they will take technology or onboarding services, etc., from a third party. So it's not a direct regulated entity, but there are prescriptions under the directives and guidelines as to what you can do, what you can't do, right? So the bigger question is that if you have access to all of this data as an LSP, and if you're simply, again, to the point that Shivli was also making, everybody wants to be a data processor in India. Why? Because the law doesn't impose any direct obligations on you. So your neck is not on the line. But the minute you start deciding the means and purposes and you're using that data, it's attractive data, eventually I aspire to be a regulated entity. So I want to, cross-sell it or leverage it and use it for my own purposes. The nature of the hat that you're wearing, whether you're a processor or fiduciary, changes. But that was a little bit of context setting, but I'm going to invite Sumeet again to maybe just touch upon various aspects of
Sure.
on this piece, please. Thank you.
Yeah. So as we were earlier discussing, look, and any digital loan which you see, right, and today is a generation where digital loans are essentially really driving up the credit dispersal in India, right? If you look at some of the recent data, and any fintech you can possibly think of, the large ones, right, will invariably will have a LSP arm to it, which will be driving a lot of their revenues also. So it's a very, very critical. When we say fintech, even the large wealth tech apps have pivoted into doing lending because that's one of the most profitable business, right? Given India is a credit hungry nation. So LSPs, there was a landmark change which happened way back in 2022, something called Digital Lending Guideline, which came in, which kind of, before that, there were a lot of question mark on how these entities were. Again, RBI finally, after came out with a very good regulation called Digital Lending Guideline, which kind of set the entire thing, which clarified what you can or cannot do. And one of the things, for example, and they paid a lot of attention to the data privacy and the consent and the expresses consent from the borrower on what kind of data. Earlier, you used to have situation where everybody used to take the entire contact address, and because you have to recover loan, you will start calling the friends, and anybody you can find, anybody will have a bhai written on it, and probably you'll have 200 people on your contact address.
That's because your phone book access also used to be with them.
Right, so you'll have probably people think this is a brother, you'll realize there's somebody who just happened to be whatever, right? So people used to, the collection agencies used to start calling them, then you knew you're a brother. You're like, no, I have never met him, no. But your name is saved as a bhai, right? Some bhai. Because there was, companies used to take access to contractors. Now what did RBI do? And this is like independent of the DPDP, right? RBI said you cannot access contract address book, right? So there was a clear choice, a restriction, because, and the argument there, which players like everybody, like large players like us used to give, no, there is express consent which I'm taking, that knowingly the borrower is saying that, yes, I'm hereby giving you express. So from a DPDP, if you look at, it's fine, like I'm calling out the purpose for which I'm taking, and the borrower is giving a informed consent. So if you just apply the DPDP lens, you're like, this should be fine, right? Because the purpose is there, why it will be there, what I can do cross-sell, everything is there. So what's the problem? The consent power is with the person who is giving that consent. But RBI actually went little, rightfully so. So I fully concur with what they did, right? Because they said that, look, when you're doing a borrower journey, people are so desperate, a lot of people, because you have, if you look at these, some of the micro loans, people are desperate to take that loan, right? So they will say yes without really understanding implication, because if you are not paying up, you have the whole contact address book which is getting opened up by when you're trying to recover that loan. And they put a specific bar. And that's why I say at least when we look at DLG, is stricter in terms of what generally your DPDP says, because DPDP that way has been designed where so long as you have these consent which expressly called out, purpose, and specific use, you're fine. But that's not how it works in the lending guideline. So that is one part. So you can't access media gallery because we have cases, right? If you look at some of the very infamous cases in Hyderabad where you had the entire media gallery being sent to everybody, your private photos, right? Which was quite disturbing. And we have a lot of unfortunate incidents which happened. So under lending guideline, obviously all of this was specifically marred. They put the obligation again on the RE to say that you have to do an annual audit and everything, and ensure that none of this is happening. So all the journey, the way the journey happened, ensure. Now what was the alternate? Now you have that the person gives one or two references which you can contact. So you're not accessing the contact address, you're giving as part of the loan journey the access that, okay, you can contact my brother, you can contact the relationship also, you can contact my friend, and even consent that, yes, these people can be contacted in case I'm unreachable. But that also is like kind of capped at 2 or 3 at max. You can't have like 30 consent being given, because it again defeats the purpose. So coming back to the LSP, right, as we were saying that LSP, you're doing millions and millions of loans, right? We have disbursed more than $2 billion loan in our lifetime in our partnership, right? And given the kind of data, again, a lot of it, the argument, if I have to put a hat where I have to argue why it should not be data, I'll say that, look, everything is coming from the RE, which is the data fiduciary. They are telling me what data to take, what not to take. So I should not be the one on the hook for this. Because they are governed by RBI, I am governed under regulation where the onus is again on through a contract at the end of the day and with the digital lending guideline. But there's no license which our LSP has to take. So, but having said that, if you look at the intent, right, given there is no denying that LSPs also process very critical personal data, financial information, and there is a good argument that LSPs may end up getting categorized as a data fiduciary. But honestly, I've had too much discussion around this with too many people because that was the first thing, and I've not had unanimous view on this. I can tell you across the top law firms or otherwise policy experts, you'll have views on both the sides, right, whether what will happen. But yeah.
Yeah, so this is in work in progress, but clearly RBI has more foresight, which is why they were putting in these data minimization, purpose limitation principles when they were saying don't access media gallery and...
I'll share very interesting,
and,
share a very interesting story which happened, right? And after DPDP, with a section now under DPDP allows you to withdraw your consent, right? We had a very interesting case. We had someone who had borrowed through the platform, and after taking the loan, he said that I'm withdrawing my consent, you can't contact me, right? This is the 6.4, and now there is a data, this is my privacy, you don't contact me, you don't contact the reference, then this is, I have my right to do that, and this is a specific law, right?
Somebody did their homework before
yeah.
they applied.
And that's why you have to, but DPDP also provides that if there is a specific use, you don't really necessarily need to do delete the data, right? Because in order for me to service the entire loan journey, obviously the person has to be contacted. I have to send loan statement or the loan agreement, right? But a very cute thing which happened when he was really convinced that no, you can't contact me, I'm taking the loan. So yeah.
I want to know, did he succeed?
No, obviously, because
otherwise I would have signed up on BharatPe as well.
Obviously, the Act provides that right. It has to be for right reasons, right? When you can withdraw, and the exceptions in the law will still kick in. But yeah, at least somebody could think about that. That let me try and do this.
Yeah, but there is an exception in the law exactly for these bad actors, right? That if you're a financial institution, you can contact them and retain their data to recover that money. Otherwise, you know, you'll become bankrupt soon. People will take taking. But Sriram, I want to move on to you now. So we've heard a lot of fintech stories, all interesting, intriguing life cases from Shivli and Sumeet. But again, just going back to the fact that startups do continue to have some obligations. Yes, they don't have the tedious notice, consent requirements, but you still have to maintain that security standard, certain reasonable technical measures that you need to have in place. And if there is, a breach or there's violation of these minimum baseline requirements that you need to still satisfy, there are implications and sanctions for non-compliance. So do you want to just take a moment, Sriram, and throw some light upon what these financial implications under the law are, and generally, from a startup perspective, which is on a growth journey, which is looking at scaling up, what could be the knock-on effects of that?
Yeah, I mean, from a startup perspective, saying that there are implications is almost underselling it. Considering there's no exemption for startups from the penal sections, there's no real moratorium on imposition of penalty. And ours is an economy where the path to profitability is very long, and 250 CR penalty, worst case scenario penalty, and that's a per instance basis, right? The dent that would put on a startup, I mean, it would put a dent on a company like mine, which is like, Zomato is like a massive company. So you can imagine for a smaller startup that's on a growth journey, for example, I don't know how you'd come back from something like that. And the smaller you are, the more growth oriented and on a path to scalability you are. Your reputational and financial risks are also very intertwined. if there is even an action initiated under the Data Protection Board against a small startup, their valuation will go for a toss, right? Their fundraising ability goes for a toss. There's unpredictability because it's not like the Data Protection Board will come out with a clear outcome in like a month or 2 months. And as long as that knife is hanging over that startup's head, you're going to have to, take a step back from growth, ultimately. So the implication for a startup, so yes, while we have exemptions, okay, sure, you don't have to issue a notice for consent, right? And you're also exempt from Rule 11, which means you don't have to take verifiable age consent. So sure, operationally it may make things a little bit easy. But if startups treat that as a blanket exemption from the law or think that, okay, they can take a more laissez-faire approach to compliance as a whole, then the downsides of that are far higher, and in fact the impact would be felt far more at that level than it would be for a, say, much larger or more profitable company. So the penal section just reinforces the fact that no matter the size or scale of your company, you're still going to have to ultimately respect the law at the end of the day and comply, no matter what the exemptions are.
Yeah, no, absolutely. And again, we had one of, not our client, but we were representing one of private equity players who was looking at putting primary capital infusion into a startup which was dealing with sensitive data, AI and sensitive data. And they said, okay, this company doesn't have basic things in place from a privacy perspective, and my IC is not going to approve a deal like this because these are baseline expectations. So if you're looking at scale and growth, and if you think, no, I'm a startup, I should be exempt because I have tax exemption, I have a whole other subsidy regime that is there to support me, your funding can be strapped. Right, so from that, and we've seen that in a live case. We got some other Indian domestic AIFs willing to, take the bet, but the international VC funds and all refuse that we can't look at this asset anymore. And that's when they got a reality check that, okay, this law has become that important, and I was only focused on, increasing my user count. Would you like to add something?
So apart from these two perspectives, like of course investment and government, I think. It eventually boils down to your ability to do business, but in a country like ours where trust deficit is anyway a problem, I believe, although at this point in time you can argue that generally people don't take data that seriously. But let's say tomorrow you are even accused of any kind of malpractices, few years down the line, I see a world where one accusation and people will stop interacting with you, right? Which of course has business implication. But and that is probably the greatest challenge to kind of climb. Penalty could be 250 crore or it could only be 1 crore, right? And maybe monetarily a startup can absorb it. But that loss could be far more damaging. Yeah, exactly. And once you break that trust, Apple has bet all its kind of money on creating that trust, right? There's a reason why they're doing it. And today it may not matter as much in India, but maybe a few years down the line it will.
And see, even in the context, it's just one anecdote that has come back to me. Even in the context of these instant messaging apps, and when I tell you the example, you know exactly what this is about. There is a platform that we all use in India, and there was a privacy policy update that came in, right? It made a lot of news. There is a fine also by the Competition Commission of India on that entity now. But during that time, there was somebody else who came up. Another platform, which at least I didn't use until that time. And they said, your data is safe with us, you migrate to our platform. Okay, so what did they do? They used privacy as a differentiator to get users. And they said, that guy may be big, but I'm good for you. And I do know a lot of people who actually migrated. They came back to the original one perhaps, and they're still there. So it's not like it was... So again, to the point that it has large business implications, and people may not want to partner with you if you don't have those baseline requirements in place. And with that, I'm going to go to the last question, and I would like everybody's perspectives on this one. Again, I personally feel that the house is divided, particularly in India, but I want to know what each one of you thinks. See, there are proponents which say that, when it comes to privacy of individuals, startups should be held accountable and should be held to the same standard as the other counterparts. As opposed to, and the reason for that again is that you want to, in your journey as a startup, that Sriram was also saying, you want to win trust of clients. And as a now, because now privacy is so much talked about, as a user, even I feel that, oh, if it's a small, random e-commerce company which has popped up, but it's asking me for all sorts of data, I'll be uncomfortable. I don't know what, they may not do anything with that data, but if they're saying, no, take it or leave it kind of thing, I'm going to be uncomfortable. I don't want that pair of awesome looking shoes, right? I'm not comfortable. Or if I cannot tomorrow seek that you tell me where all have you sent my data, I mean, I would like to have the right. I may not exercise it. It's like, going to a party. You want to have the invitation. You may not eventually go. So it's like that. So I feel that is it not better in the long term? In the short term, this exemption might look very attractive because it's exempt and the government is trying to help you. But in the long term, do you think it really makes sense that might as well have privacy by design and all of these requirements just embedded today itself when I'm putting my software together, as opposed to taking a benefit now and then trying to open up my products, re-engineer it, and say that now that I'm no longer a startup, I would need to comply with a whole host of things. So any thoughts there?
I have an anecdote I can share to validate your point, and you made that earlier point as well, because it is a differentiating factor today, privacy, and you can also, if you're smart enough, leverage it as a selling point. So I'm also the data protection officer for Blinkit, right? And we got a standard amount of account deletion requests. We rolled out a feature for specific order deletion. You would have seen tweets, maybe if you've used Blinkit, you would have seen it. You don't need to delete your account. If there's one particular order that you're not comfortable with, and there are certain categories of products that we sell on e-commerce platforms that you may not be comfortable if you're sharing a device, because you can talk about privacy all you want, but within the Indian family unit, maybe privacy is not first priority, right? And there's a lot of shared accounts, and
DPDP doesn't apply.
DPDP doesn't apply. So, yeah. The week that feature went live, thereafter our account deletion requests have practically dropped to zero, because nobody really needs to delete their quick commerce account as long as they have privacy built in. And that's a feature of convenience. And if other platforms don't have that feature, then they're more likely to use the platform that does. So privacy by design goes a long way, because it, like Ravi also pointed out, we operate in a trust deficit society by default, and convincing your customer that, all we want to do is provide you the service that you've asked for. We're not here to harvest, sell, or in any way exploit data in a way that, may not have been a conversational aspect at least 5 or 10 years ago, and today your data is secure, and that's a selling point now, which may not have been a while ago. So that really helps.
I think top-notch answer, Sriram, on that. Shivli?
I just want to share something that happened today, and I think it's not just on the top of the mind of startups, companies, it's on everybody's top of the mind. So I flew in for this conference, and I used Dibyojyoti because I wanted to make it hassle-free and all of that. And interestingly, just as I finish doing everything that I need to do to make sure that I have a smooth journey, there is a pop-up that happens, which, like many other apps that we use, says, your year in the past. These are the, songs you listen to. These are things, it gives like a, what's it called? A wrap, right? Yeah, a wrap up, right? So, and I got invested in it. I said, okay, let me see where all did I go last year. And I went through it, and they said, these places, etc., etc. And they're just taglines. What places did you visit? How many times did you fly? And at the end, they say, your data has not gone anywhere. We don't know what you did. Literally, something on those lines. And that, yeah, your data is safe with us. And you can imagine how it's stuck, right? Because that's such a trust building mechanism that, look, you don't have to worry about where your data is. It's safe, right? So it's that, I think, becoming integral to everybody's mindset that where is my data going? So yes, investing in it is a definite yes. How much you can invest in it as a startup is something which, like, I'm going to refer to my comment I made earlier. It's a work in progress. Everybody will see what the other one's doing, etc., etc. And last but not the least, I don't think we can really escape it. And even before DPDP, we had the SPDI rules and all of that. So there is a bare minimum that must be done. And maybe that's the starting point.
it goes back to if you have to understand why this kind of exemption has been envisaged, is obviously to promote, not to saddle these startups with extra compliance, which they may not be really ready at that stage. They're still building up. They may be bootstrapped. They may be at a very early stage, but still in a sector where there's a lot of sensitive data which is being processed by them. And ministry has come out, right, because they're saying that no, this is for regulatory sandbox. You have to have a sandbox kind of thing where you can do a product development, and that time you don't need to do it, but once you go live, you may still need to do it. My challenge is actually some of the sections which they have. I can understand why they want to exempt the STF requirement, because that is obviously meant for much larger entities. And again, I'll go back to a first point of our discussion, that who is really a startup here, right? I don't think like most of us here will categorize as a startup, right? So it's essentially meant, let's say, people who still maybe in what we call a Series A or a Series B company or a pre-Series A company or a seed company, right? Where your turnover, like it goes back to the DPIT discussion we were having, is still under 100 crores. Because the government felt that, look, if you're still under 100 crore revenue, that means that you're not become a very large player to make that kind of, your customer base or your size of the business is not such where you can, you should be subjected to a stricter or a threshold requirements of the DPDP. That is the intent. But what it does is that, as now with everybody becoming, you have somebody in tier 4, tier 5, they will not understand. Nobody will even know what is DPDP, right? So people download the app, they'll say next, everything's done, right? But what it does actually for startups is to, if you have exemption that I don't need to tell you why I'm processing your data and for what purpose, obviously there's a lack of trust which kind of creeps in, especially let's say in people who understand or fairly educated to understand the nuance, or people who are sensitive about what kind of data they are sharing, especially after these regulations. So startups should still try to have these policies, more robust policies, and make that disclosure on a voluntary basis. Obviously anything which kind of put onerous obligation on them and they just don't have the size or scale to deal with it. That is the intent, right? That look, you may be too small, given there is no distinction. If I'm a Series A company or a Zomato, if I breach, the penalty provision is still there, what it is, right? So, and it may lead to essentially shutting down of the businesses. So they don't want to stifle growth or development or whatever product innovation these startups are doing. But at the same time, I think there still needs to be a balance, and it will be incumbent on the startups only to do those voluntary, and to, even though this is not required to be done, it will build in more trust, right? If you still go ahead and tell them why I'm taking this data and what I'm going to do with this data, or I give you an option to delete this data or retain the, I think it will help to build that trust. And but I still think that it's a good step, given that at a very early stage, when you're still probably running something out of a room, right, to suddenly being overburdened with a stringent compliance which requires a lot of investment at your end, is just taking the focus away from product innovation. So the intent is good, but we'll have to see how this plays out. And I think with this kind of thing, you can always go back and they can always clarify or relax or make something more stringent, right? This is still very early days, we'll have to see how these regulations play out and some of the practical challenges which everybody faces once this is finally out.
Thanks. Ravi, final comments from you on this?
Yeah, so I'll pick up from where he left. See, the way I see it, there are broadly two reasons. One is about the costs. Now again, with this law coming into force, I feel there will be innovation on creating solutions for that problem as well, which will bring down the costs of implementing these measures as well over the next few years. And so that will eventually automatically happen. And the second reason that I can think of, although both of them are connected, is probably one of the reasons why they decided not to kind of impose these obligations on the startups, because most of us are still figuring out what these obligations are going to look like in reality, right? So maybe of all these people, startups are the least kind of capable of handling it, so give them some breathing space. However, as we develop and more solutions, I mean, if I were to look at it, if there's a new brand of shirt company which is trying to sell me those shirts, we will, or probably we have already reached a stage where rather than showing those shirts with some fancy models wearing it, compared to another company which is just plainly putting that a picture but making sure that my data is dealt with properly, I would choose the latter, right? And both of them could be startups. So I think sooner or later that reality will dawn on them. And
Don't pay for the model, pay for the
exactly, yes, precisely, yes. I think that will anyway happen, and I feel that will happen well before the government starts thinking of imposing actively those obligations on the startups. Yeah, thank you.
Thank you so much. All excellent points made. I have also taken away a lot of things from here, but I hope you all enjoyed the discussion. We have overshot, but I think that's a sign that it was an engaging discussion that we've had you all for so long here. Thank you very much. Have a great day.